who will be moderating this session and taking us through this interactive and great content. Over to you, Yasmin.
Thank you, Mpumi. I hope you can all hear me. Thank you for that very enthusiastic introduction. I feel like I don't have to do any more introductory remarks. But let me jump in immediately and say, welcome you all warmly to our first plenary of our 15th annual conference. We're very proud to be able to host it, even though we've been having to do it virtually again. As Mpumi said, the topic for this plenary is lessons from the pandemic for future competition regulation. Now, we've all heard and have probably experienced firsthand the havoc that COVID-19 has wreaked on the world. We've seen fragile economies fail, we've seen supply chains become vulnerable, and we've seen, more importantly, the deepening of inequality and poverty. One of the things, of course, is that apart from the negative aspects of this pandemic, what it has done is provided us with an opportunity to think about this world in a different way and to find new ways of working as we are doing. So throughout this period, the competition agencies have been at the forefront of price gouging enforcement actions. And I think that I have not seen, I stand under correction, any other institution in any country actually taking the cudgels to protect consumers in very fragile and vulnerable situation of a pandemic. We've done this, and now we are facing a possibility of recovery and reconstruction because vaccination rates have increased, and we think that we might have arrived at a point where we think we would have to learn to live with this pandemic and find a way to reconstruct and recover. So as we turn our faces to the future, we ask ourselves the questions: what have we learned about regulation in this pandemic? What lessons can we take from it? And how does this influence or affect our future competition regulation? And this is the panel where we will have some of those insights. So let me introduce you without further ado to my distinguished panelists. Start with Ms. Mondo Mzwai. She's well known and more distinguished than I am, Mpumi, having served at both Competition Commission in practice and is now the chairperson of the Competition Tribunal. Mondo is a lawyer by profession, and her bio is available to everyone. So I'm going to move on to Hardin Lachisusu, who's the Deputy Commissioner at the Commission, also well known and highly distinguished. We've seen him around for a number of years. He's served in many different capacities at the Commission. Welcome, Hardin. It's very nice to have you. And let me then move on to Mr. Francis Kariuki. Francis, it's lovely to see you again. And I'm pleased to just introduce you as the Director General of the Competition Authority of Kenya. But you're a solid colleague of the South African agencies, and you've always been supportive of our work. And it's very lovely to see you, and thank you for participating. And just to tell our audience, we were supposed to have a fourth panelist, who some of you might know, Diana Moss, who's works at she's the president of the American Antitrust Institute, which is an NGO working in antitrust in the US. Unfortunately, she couldn't be with us due to a family emergency, but we will try to do the best we can. So, without much ado, let me just quickly give you some, before I turn to you, Mondo, let me just give you a bit of a roadmap. I want to focus on themes. I want to take a thematic approach in our discussion. And the 4 themes, I'm actually going to do 5 themes. The 5 themes that I want to focus on are price regulation, merger control, exemptions, agency effectiveness, and then finally the 5th one will be the African Continental Free Trade Agreement, which has become very important for us and probably will have a very significant role in reconstruction and recovery. You might have, I won't limit you in your presentations or responses to my questions, but I will try to focus on the themes as a guide to us getting through our limited time and getting our reflections a little bit more focused. So Mondo, let me turn to you and ask you, you have been at the forefront of some very critical and novel cases adjudicating at the tribunal and first-hand experience of particularly price regulation. But please share some insights with us, some lessons that we could share it with us, and perhaps we can just debate them as we're moving on. Mondo, you have to unmute yourself. I will have to remind us all to unmute because this is our occupational hazard on virtual platform. Over to you, Mondo.
Thank you, Yasmin. And thank you for the introduction earlier. And good morning to the participants on this virtual conference. Good morning also to my fellow panelists. Yasmin, I'll just give my brief reflections on the 5 themes, as you mentioned, and may perhaps go into detail as necessary as we go along. Let me just start by saying that I think it's uncontroversial to say that the end goal of competition regulation is the eradication of market power, whether it is through the abuse of dominance, cartel behavior, or through a merger. In a developing economy such as South Africa, competition law and policy also seek to address specified public interest. Pre and post the pandemic, this goal of eradicating market power remains the same. It is the true north of competition regulation. So what did we learn about markets during the pandemic? I limit my observations to 4 things. The first is that we learned that markets can fail as a result of supply and demand disruptions. As consumers scrambled to procure protective equipment and essential items such as masks, they were confronted by instances of suppliers taking advantage of the crisis by hiking prices. Suppliers defended their actions as a simple response to increased demand against limited supply. Consumers, on the other hand, believed that they were exploited when they were at their most vulnerable and called on the competition authorities to adjudicate and to show the visible hand of regulation. What is key here is that the regular provisions of the Competition Act as amended in 2019 were sufficient to address the market failure in the context of the pandemic. This tells us that the lens through which consumer harm can be examined is embedded in the Act. What it boils down to is an interpretation issue of facts, the economic evidence, and the relevant legal principles. Indeed, the Constitutional Court has reinforced in Mediclinic, in the judgment issued last week, that the Bill of Rights is central to the interpretation of the Competition Act, and the Commissioner touched on this earlier in his opening remarks. The second point, which is an observation, is the complementarity between government policy and competition, especially in this instance of excessive pricing. In South Africa, the government acted swiftly to introduce specific excessive pricing regulations related to COVID. The 2 landmark cases were decided on the regular provisions of the Competition Act because the price hikes took place before the regulations came into force. The regulations didn't set any new law. They simply provided an additional benchmark for excessive pricing. Other swift interventions implemented by government include block exemptions related to the healthcare sector to enable healthcare providers and hospitals to collaborate for example, on capacity. In the banking sector, banks were allowed to coordinate on payment holidays and debt relief for their customers. In the retail sector, they were allowed to coordinate on payment holidays and rental discounts for designated retail tenants. Governments across the globe have implemented similar measures in varying degrees. And while it may be necessary to put these ailing industries in critical care, they will need rehabilitation. The question is, how long should they be on life support for? Should there be a sunset clause? Who determines when the life support is pulled? This is an area that will require ongoing consultation between government and competition authorities. The third observation relates to merger control. Competition authorities across the globe reported an increased number of mergers as a result of consolidation and failing firms. South Africa is no exception. The prevention of market power and concentration is what merger control is about. The Commission has embarked on a study of concentration, and it will be launching its outcome of the study in due course. This will hopefully provide some pointers in the areas of complementarity between industrial policy and competition law, because the two must work hand in hand. Of course, market inquiries remain a tool at the disposal of the competition authorities. The question about the failing firm defense in mergers has been whether the assessment should be more lenient during the pandemic. The South African experience has been that most of the firms that have raised a failing firm were mostly firms that were already in distress pre the pandemic. Given the permanent structure in the permanent change in the structure of the market, our approach has been to apply the same test to the failing firms. The public interest, predominantly saving jobs and preventing the exit of assets from the market, loomed large in these mergers and held a lot of sway in the outcomes of the decision. And the fourth and final observation I'll make is how the pandemic has changed the way in which business is done. We have learned of the efficiencies of online business through technology. Indeed, most of the work of the agencies reported earlier was done during lockdown. We quickly introduced procedures for hearing matters virtually. In some instances, we heard the matters on the papers without the need for parties to attend. We prioritized cases with the most impact, initially excessive pricing complaints and mergers. Some of the efficiencies realized from the online work experience will become a permanent way for doing business and for conducting hearings, for instance, in the phase one merger cases. Adopting these efficient measures will help us to focus more resources on complex matters, such as the abuse of dominance and cartel cases, which were largely held in abeyance during the pandemic and are likely to be worsened by the pandemic. The prosecution of excessive pricing had a deterrent effect, but also knock-on efficiencies to our proceedings, since during and following the findings in the excessive pricing cases, we decided 63 consent or settlement agreements virtually, which would have taken more time and cost in a physical hearing. The efficiencies realized from online work has boded well for global and regional cooperation of the competition agencies. Capacity of competition institutions, especially locally and regionally, will have to be strengthened if the full benefits, especially of the African Continental Free Trade Agreement, are to be realized. Lastly, I think it is fair to say that online digital markets have been in a boom and have been largely not affected by the lockdown restrictions. They've also attracted scrutiny across the globe, and South Africa will be commencing online intermediate platform hearings in November, and the Commissioner alluded to this at the beginning. This is certainly a space to watch. And so not to preempt the inquiry, I'll stop here, Yasmin. Thank you.
Thank you, Mondo. That is very well summarized presentation for foreshadowing our discussion and contextualizing it. So I want to turn to Hardin and ask him to come in and maybe let me take it thematically, because I think to keep to the flow, and we can move conversationally through it. Let's focus on price regulation. I mean, we know we've done a lot in that area, but before you speak, Hardin, I just want to put up a quick disclaimer there to the audience that even though you all represent agencies, on this particular panel, your views are your own and should not be attributed to the agency. And I want you to feel free to converse, and even if you have to contribute, please don't restrain yourself in any way. Hardin, this in some ways, this regulation of pricing was, we've seen criticism from some quarters saying competition agencies shouldn't be intervening in the short term on excessive pricing. And then we've also seen the benefits of intervening in the time and giving stability and security to certain supply chains and to consumers at large. What has been your experience of it, and perhaps share some insights also in terms of the workload that the competition agencies ended up having as a result of those regulations?
Thank you, Yasmin, for that and for the kind introduction. And I think it's really a pleasure to participate in this panel. I think with this esteemed panel, Mondo and Francis. And of course, greetings to the participants today. It seems to me, and the pandemic, in fact, I think South Africa, we have been through a lot as a country. So starting with apartheid, I think 46 years of racial exclusion and really no opportunity for participation by the majority of our population, which led to the kinds of market structures we have seen. So we have inherited this economy that is not competitive at all. It is an economy that, unfortunately, just post-94, we had even other crises. We have not yet recovered, by the way. This is what economists say, from the 2007-8 financial crisis. And now we are facing the COVID pandemic. And we see rising levels of inequality in South Africa. As Mondo was saying, I mean, there are firms that are doing very, very well during this time. And unfortunately, the benefits tend to accrue to fewer than, fewer of those firms that we see in South Africa. So there is some context here that I think is important, that we have a risk in South Africa of market structures that could, prone to create failures. But we are also seeing failures, not just in a context of South Africa, even in developed countries. There are these failures, and I think the digital markets have shown, pharmaceutical markets, as we speak, Europe has taken on a number of cases. The US is beginning also to be concerned. So I think for us, this idea that we should not intervene in markets does not find, firstly, expression in our law, the Competition Act. It is something that is also does not talk to our context as a country. So if we do not intervene in the market structures we have in the country, there will definitely be exploitation. And I think COVID-19 showed this. Immediately, there was a declaration of a state of national disaster in March. Companies started increasing prices of basic necessities. We had to step up and intervene as the authority. And there were successful cases. I think Mondo has spoken about that. We were inundated with complaints from the public, not just on those essentials for COVID, such as sanitizers, masks, and so forth, but also food products. And our intervention, in our view, has caused a lot of restraint on firms. We did not have a lot of cases in food that we had to refer, because as soon as we engaged the retailers, they agreed that they have to restrain price increases. And that was also supported by the government, the minister publishing regulations. These regulations, and we were fortunate, by the way, that a year before, the president had passed amendments to the Competition Act, because this was not going to be possible. The amendments strengthened, excessive pricing provisions. I mean, 20 years, it was very difficult to win excessive pricing cases. It's a matter, was it a structure of the law or how it was being interpreted in higher courts? That could be a different debate. But what we found is that the amendments were very, very useful for us. But also, we collaborated with authorities on the continent immediately as the ACF. We had a get-together. Francis was there. Botswana, Mauritius, a number of countries where we had to get together to formulate a response for Africa. And it was clear that we had to intervene in these pricing issues. And it does show with the interventions we've had in South Africa. I know there have been interventions, through consumer protection, even in Kenya, just requiring the restraints that you should. And I think we are really setting the trend here, Yasmin. I'm getting a sense that even when we discuss these issues at the OECD level, there is now some understanding. In fact, we had a discussion on excessive pricing during the pandemic at the OECD. There is acceptance that there are areas where competition authorities have to intervene. So this is something that we think is quite important for competition authorities, even with different backgrounds, different challenges we face. It is something that we need to look into.
Okay, so what I'm hearing from you is that, yes, we've done it in this pandemic, and we've done it in that context, but we actually think that we might need to do it in the future as well. And I think that's what I'm hearing from you. Maybe let's come back to that. Let me hear from Francis, because you mentioned, Francis, you can give us a little bit more insights and information on how you've handled it and your views about not just current price regulation, but how you see it going forward.
Thank you, Yasmin, and it's a pleasure to be in this panel and also to interact with South Africans in general. Today, Kenya, it's a Heroes Day, and I'm happy to interact with South Africans' heroes. Thank you very much. Yasmin, from where I stand, is that when any national legislature is enacting a law, is to attend to the situation and the ecosystem in that country. And therefore, any law legislated should be aware of the challenges maybe facing South Africans, your historical anachronism where you faced all those challenges, and any law, any competition law which is enacted should be able to attend to that kind of inequality. And therefore, is that it's very difficult to say that we transplant all kind of laws from different, maybe across continent to attend to our situations. We can learn through international best practice and be able to domesticate to attend to our challenges. And therefore, I'm not in a position to say all South African approach is good or bad. It is the problem which it is attending, which is akin to the South African regime. Having said that, is that I'll also revisit what Mondo indicated. We have adequate laws. It's the issue of being flexible and interpreting the law purposely to attend to a certain eventuality. And this is what I saw during this pandemic. Number two, I'll revisit what Dr. Fikeni said in terms of leadership, the flexibility of leaders, and to be able to identify challenges and solutions and prioritize to achieve what we want to achieve as competition agencies. Having laid that background, is that the Competition Authority of Kenya approached the pandemic with what we called quick, impactful interventions by first interpreting the law purposely and liberally, in a manner to capture as many issues as possible. Number two, the aim was to make and ensure that the markets are functioning, especially for essential supplies. That is food items, PPEs, and also sanitizers. And to ensure this is that our prioritization was focusing on ensuring that we have an uninterrupted supply chain. And obviously the supply chains could be interpreted by having exclusive contracts between manufacturers and retailers. So our first order was to ensure that we expunge those exclusive distribution agreements. The number two is that the supply chains could have been affected by the government's COVID protocols, zoning of areas, that the trucks supplying goods and services cannot cut across the whole country. And therefore, we were working with the government emergency committee in terms of liaising with them how prices are changing, and yet some prices in some of the areas are not changing because the goods cannot move. So this showed how we can cooperate with other government agencies in ensuring that we have unfettered distribution channels within the economy. The other area, and I'm happy my friend Hardin has mentioned it, it's also working with the manufacturers. We used our general rules to tell manufacturers to be supplying us with their production capacity volumes every 2 weeks and whom they have sold to. And then we could go to the retailer and ask them, how much do you have? And you sold within how much? So that exposure and sharing with the public in terms of goods are available within these areas also ensure that the consumers knew who is holding or not holding. So that kind of transparency. And what I realized is that during a pandemic is that you try to salvage each and everybody. When you're drowning is that you don't say that I'm rich or this one is poor. You try to salvage each and everybody. And there was a lot of coordination in terms of enforcement between the manufacturers, ourselves, and the government. Also, we used other provisions within our Competition Act, abuse of buyer power provisions. If at all you don't pay your suppliers, obviously the goods will not reach the consumer. And with our intervention, we ensure the suppliers, especially the small medium enterprises who had been owed some money, were paid Kenya shillings 3 billion, and they were able to continue supplying in the market. And therefore, of course, this ensured that there was no price volatility. Now, akin to what the South Africans have in terms of excessive pricing, we have an unconscionable conduct kind of provision. And our first case of coronavirus was announced on March 13th, I remember very well, on a Friday. And on 16th, that is 3 days after that, we had issued an order to a retail supermarket, which had increased the sanitizers by 200 shillings. You know, they were selling at 400, they were selling at 500, and after the coronavirus case, they just changed the price tags and placed that it's 700 shillings now. We visited the supermarket, and they could not explain how a sanitizer, which was on the shelves, can increase by 200 shillings just because a coronavirus case has been announced in Kenya. And with this, we issued an order. They refunded all the people who had bought the sanitizer. And there's something which brought a lot of sanity in terms of how people were increasing, you know, and we worked also with the executive. The president was very clear that whoever increases the prices without the variables of supply and demand, he'll face the wrath of the Competition Authority of Kenya. He said it openly. And that kind of engagement with the executive and also the press ensured that the prices which were being offered, they were market prices. With this kind of intervention is that you realize that the price volatility in Kenya in 2010 and at the peak of Corona had only changed by 0.21%. That is the inflation. And I attribute this to the kind of intervention we engage. Also, the government itself put in some tax rebates to some computers, to some consumers to spur demand for the manufacturers and producers to produce more. You know, all those somehow affected the functioning of the markets and ensured that the prices did not hike. That's how we approach it in Kenya.
That's quite impressive, Francis. I mean, I commend your work. It seems very intense and dedicated, but it does raise this one question for me, that you actually had a competitor when you walked into the store that had the old sanitizers there and an old cost price, and then just increased its price without an increase in the cost of that product. And in excessive pricing cases, that's usually been the concern. So what are we comparing with? You know, where's the competitor? One of the advantages that we had in this period through the regulations was that there was this comparative margin comparison we could do. And the Commission has relied upon that. But if you turn to how we would use it in the future and say, well, if you're looking at reconstruction and recovery, firstly, which sectors would you think about that we would want to regulate for excessive pricing, which in itself is quite difficult because you have to do, it's quite an involved exercise, requires a lot of capacity from the agencies, and what would be our competitors in such a sector. So that's the first. And the second is, but in such a situation, when you're looking at recovery, let's say, for example, you're looking at hospitality sector or some kind of food manufacturing sector, small food manufacturing sectors, what would you do in such a situation, utilizing price regulation in the form of excessive pricing as a way to assist the sector in recovery? Ought we not be thinking of ex-ante regulation then, rather than ex-post regulation?
Thank you, Yasin. Let me dwell much on this case of unconscionable pricing and how we arrived at that. It's one of the influencers on Twitter who shared with us and said that such and such, in fact, it's in the public domain, it's Clean Shelf Supermarket was selling sanitizers at 500 Kenya shillings. After the case was announced, it is at 700 Kenya shillings. How we work there is that what I can share with the plenary is that also we have excessive pricing provisions. However, the excessive pricing provisions, we have to determine dominance first. And when you determine dominance, now that is when we go to excessive pricing. Obviously, there have to be comparators. We saw that that cannot deal with a pandemic issue because there's a lot of academic work. And we saw that there's a provision on unconscionable conduct, which says you check at the vulnerability of the consumer and whether the consumer has some substitutes or whether you are taking, and we are taking advantage of the vulnerability of the consumer. And we saw that there is a soft route to follow. And how did we look at it? That to ensure, to see that these prices were not being driven by supply and demand. We just called the supermarket and asked them, which brand is this? They told us it's this brand. Then we called the person who was manufacturing the brand. How much did you sell this brand to this person? And when did you sell it? We sold it some days back at this much. And this person is that also we called upon the people who bought, and they said even some were being, after the announcement of the corona, that is when the price tags were being changed. They had already acquired the product. So the comparators is that nothing has changed because the good is already on the shelf. It's just your own greed and taking advantage of the consumer. And that is when we say that you are utilizing that is an unconscionable conduct. We decided not to go litigation to penalize because also it would take a lot of time. We just made a commitment decision that anybody who demands to be refunded will come on board. In terms of the
can I just ask you there, and maybe we can come back to that issue. And it's something that Hardin said, something about the fact that you're looking at a more of a consumer protection kind of provision in the legislation. And question I have is, all right, that's great if you have it, but going forward, when do we intervene as competition agencies is still important because we have limited resources. So if you're going to intervene in, say, for example, ginger prices in the same manner that we've been doing under the COVID pandemic, is this a sustainable way of exercising our judgment on intervention? And should we in South Africa not look at something like your provision and the Kenyan provision in order to do a more consumer protection kind of initiative? And maybe let's ask Hardin to come in on this debate, and Mondo, you can too, because this is where I think, the rubber hits, what is it expression? Because we have limited resources. We just cannot sustain the kind of intensity we have, intense pace we have been doing in this period.
Maybe before they intervene is that my greatest lesson is that I've seen collapsing some of the provisions, consumer protection, bringing them under the Competition Act, and also the superior bargaining position provisions under the Competition Act you can be able to, let me use a term, to be able to be flexible enough from competition to consumer protection and critical trading partner and superior bargaining position. Number two, as an institution, having this under one roof, it ensures that the decisions are taken very, very quickly. And as Hardin talked about cooperation in this time, is that you'll be able to have that decision taken within a short time, especially when it's a pandemic. That's what I would indicate.
So Yasmin, maybe I can chip in. I think you are asking it's a difficult question. As I've said, I think the amendments to the Act in South Africa have refined the excessive pricing provisions for the better. And what we have seen with the regulation that was published, it was not of course it did identify sectors that it would apply, but the principles were generic in nature, that we would look at exploitation broadly. So if, in fact, that was just to assist firms to know the parameters we'll use, that if margins increased, during the pandemic, there has to be some explanation. That is what we were measuring, because we accepted that maybe input costs could also increase. Those were the cases that we were looking at. And I think this is still a price cost test kind of assessment, if you look at it. So that regulation, in our view, exists. I think what the minister did, which was creative and really was to assist firms, was that this is what the competition authorities would consider in the context of this pandemic. So we think, these are very good, lessons. In fact, beyond this, we even witnessed for the first time simplified procedures before the tribunal. This is something that we are always, getting questions. Why do your cases take this long? Can't you simplify procedures? We experimented with this, and our tribunal was quite receptive. Minister again publishing a rule to permit that. So there are a lot of lessons here, and I think that's why I don't think we can throw away the cases that the precedents that have been set, in Babelegi and Discam. Those cases, in my view, will influence how we will be approaching excessive pricing going forward. In fact, this is I read the judgment, it says not much has changed, but for us, I think a lot has changed. And we have clear regulations in South Africa. We don't necessarily need other regulations. I think, I agree with Francis, we have a competition instrument. We had to apply what we had as the Competition Commission. So we looked at that, and dominance in South Africa, by the way, Francis, it's a very broad concept. FM, it's about market power, essentially. I think market shares matter, but they don't matter that much. So I think the context here was, and I think how the law has been structured here on dominance is not restrictive at all, which enabled us to prosecute these cases. That's why we could take them. And Yasmin, it's not even about, so if you look at it, we had 2,000 or so cases. We probably referred close to just under 15, mostly settlements, very few contested cases. I think it took a lot of resources from us, but these are not very complex complaints to screen, right? So we did not have that kind of a challenge.
Yeah, Mondo, you can come in on this, because I think that the issue here is certainty to investors and businesses as well. We, on the one hand, we say we will intervene, we need to intervene, but we also need to give some kind of guidance and certainty to businesses and investors, potential investors.
Absolutely, Yasmin. I think the issue about the excessive pricing cases is that I don't think that they mean that there should be a wholesale importing of the principles that arose out of those cases into all the sectors. You asked the question about whether there should be price regulation in certain sectors and how the excessive pricing cases can be used to do that. I think we still have to come back to the harm to consumer and the theories of harm from a competition perspective. I think there are two things there that would help to guide that question. One is that the concentration study that the Commission has embarked on is one form of identifying sectors in which interventions may be required. And I'm not necessarily saying that those interventions would be excessive pricing interventions, but they would indicate areas in which there are market failures and appropriate interventions can then be sought. The second area that would be helpful there, and is probably a marker and a starting point, is the actual reconstruction and recovery plan itself, because it identifies certain sectors which are priority sectors and are key for growth and development in the country. And some of them include energy, the telecom sector, and both those sectors in their own ways are already regulated. And so the issue is going to have to be about looking at the regulations by industry sectors, as well as competition regulation, in order to achieve the optimum outcomes for markets and for consumers.
That's very useful, Armando. And while you're on that point, let me swing us to the issue of exemptions, because you flagged that in your input. And while we're looking at recovery and reconstruction, you mentioned how we used exemptions during this period, and I want the three of you to focus on identifying through your experience whether there are any sectors that you think would benefit from that, whether it's a tool we could use for reconstruction and recovery, and the duration of it. I mean, just like try and focus on a forward approach to this. And perhaps I just give you 5 minutes each to talk about that. And Mondo, you can go while you are here.
Yes, I touched on some of the exemptions, block exemptions that were given to various sectors. And understandably, the sectors are employment intensive, and therefore the concern was about sustaining those businesses in order to achieve the public interest elements of the Act. So we see that in the banking sector, we saw that in the healthcare sector, particularly because this was a health crisis and a threat to human lives. And therefore, those sectors were appropriate to intervene in. The issue that remains unclear and is something that would need to be visited by the competition authorities, as well as the relevant government departments, is the duration of the exemptions. Because from a competition perspective, our concern would be about creating permanent market structures of coordination among competitors and not allowing competition to thrive. And so that's really the question that has to be asked is how long, as I mentioned earlier, that these interventions of block exemptions were necessary in order to put these industries in critical care, but they will need to be rehabilitated to normality again in the interest of long-term competition. Let me stop there for now.
No, thanks, Mondo. Let me jump to Francis Hardin. I'll come to you. Let me ask Francis first what his views are about utilizing exemptions, whether they've done it now in this current pandemic period, and how he sees it going forward.
Thank you, Yasmin. The Kenyan law provides for exemptions, and on case-by-case exemptions of certain of our criteria set very clearly under the law. And when you're exempting, is that you exempt to maintain or promote exports. You exempt to improve or prevent decline in the production or distribution of goods and services. You exempt to promote technical or economic growth or stability in an industry, that is to encourage research. But also there's what I may call a sweeper statement, which says that the benefits accrued from lessening competition have to outweigh the disadvantages of lessening competition. And during this process is very public. It is a process which undergoes very serious public participation, because you have to put it in the Kenya Gazette, request for people to give opinions in regard to how they may be affected with that kind of an exemption, or how they may want you to frame the conditions. The agency may approve the exemption, but there has to be a time limit. And you can say 3 years or 2 years or 5 years, depending on which sector, if at all it's research or something like that. Number two is that you can approve with conditions, giving warranties, that I give you conditions that you give, I exempt you. However, you have to maybe produce this amount of goods and services in the market so that you can deal with that situation which is facing the market then. So there are those warranties. And during the pandemic, the only exemption which we attended to was in terms of evacuation of cargo, where the cargo planes said that we cannot fly all our cargo planes in Nairobi, Is there a way we can be able just to fly one cargo plane so that we can consolidate all the exports from Kenya? And that is something we looked at favorably, because also it was dealing with the supply chains in terms of also supporting our farmers exporting flowers and teas outside Nairobi. And at the same time, we saw these cargo planes also bringing in PPEs. So that was a very key area to bring in exemptions. However, in terms of the process, it takes quite some time. And we are thinking of how we can be able to make it respond to a crisis. Because when you're in a pandemic, going through public participation, which it has to be 30 days, then coming up with a report, you might not attend to that problem. Then the other area I would like to share with the plenary is that also we thought about block exemptions in some certain areas, focusing on the hospitality industry, focusing on SMEs who are suppliers in some areas. But also the process is it takes some time. We forwarded to our minister. We are supposed to develop with our minister. It is still ongoing, and obviously it seems to have been overtaken by events. But moving forward, we feel that exemptions are good when the threshold is very clear what they have to meet. Number two, the timelines. Number three, their warranties during that exemption period. We might be requesting Parliament to donate some powers in terms of flexibility during a pandemic only. Thank you.
Thank you, Francis. You might have a definitional problem there as to what constitutes a pandemic, but I understand your difficulty because we also have it. Any comments you use about exemptions and how we could use them, with particular focus on duration, of course?
No, of course, indeed, Yasmin, I think exemptions have been a very useful tool for us in South Africa, for the Competition Commission. I think this is well covered under Section 10 of the Competition Act, and this has been expanded. I will continuously refer to the amendments to the Competition Act because the provisions were quite narrow up until 2019. We now have wider provisions that we can grant exemptions looking at economic development and many other variables as the Competition Commission of South Africa. But also there is a Section 1010 provision which empowers the minister to issue what we can call block exemptions. So what happened during the pandemic in terms of agility? We found that, and similar constraints with what Francis has described, that the block exemptions, at least in our case, we thought they would be quicker, and they were. We engaged, quite swiftly with government, Department of Trade, Industry and Competition, Minister Patel, in particular, and we had, exemptions in the health sector, banking sector, retail, hotel, but the scope of these exemptions is quite narrow. It's really for stability. They don't exempt a price coordination in the main. I think the one that allowed for this was the health sector regulation, but we said this must be coordinated by the minister, by the government itself, because they needed to deal with various pricing issues around what would cost a bed in hospital, the vaccines, I'm sure if we had them, but also these diagnostics kits that needed to be used. So this is a very useful tool for us. And going forwards, I see as part of reconstruction and recovery, you're going to see a lot of this in South Africa. By the way, government is adopting a number of master plans. We have already issued an exemption in the sugar industry. So already we are in recovery mode in South Africa. We have an exemption now targeted at the sugar industry so that they can get together. We have published guidelines on competitor collaboration to promote localization initiatives. Again, as part of economic reconstruction and recovery, our government is focusing more on localization. we are seeing a lot of requests on that. And this concentration study also, it's showing that there's very limited participation of SMEs in the market. There could be a response there where you could see, this is under consideration really, a wider exemption for SMEs to be able to procure collectively, because we are seeing that there is very limited participation of SMEs in markets. In terms of duration, I don't think I can have an answer. We have about 2 long-standing exemptions. We have an exemption in the fuels space where they have to coordinate supplies from inland, from the coast to inland in South Africa, the Fuel Association. That exemption has been running probably now for over 10 years. We have an exemption exempting the independent hospitals groups, the NHN, the National Hospital Network. That exemption has been running for a number of years. The only thing that we are cautious of is the price aspect. So even when we issued these localization guidelines for competitor collaboration, we have excluded price because we would prefer that any agreement on price, there has to be either a formal exemption application to the authority, and we can build in conditionalities there because we have to build back better. It is very important. I don't think we are going to be giving away, just exemptions with the hope that there will be some recovery. There have to be deeper engagements with these companies. So maybe I cannot tell you exactly, for the pandemic, they were very short term. They are still ongoing, but for recovery, it might take some time. I think the sugar one, we had granted it for a year. They wanted more time. So you are looking at roughly 5 years for these kinds of exemptions. Thank you.
Might be a long period if you were in the mobile telecommunications industry and you got some access to spectrum and didn't want to give it back after 5 years.
That's why we were not going to entertain an exemption from that sector. I think they are in a good space.
Another first mover advantage in those network industries can be very seriously advantageous in a very short period of time. So I'm quite surprised to hear that. I do know about the fuel exemption and that it's probably been running since the World Cup, because that's when it was first granted, I think. So yes, you're saying it depends on the sector, and we'll see where we go, and that it is an important tool. But let me then, when you're talking about SMMEs, let me come to the issue of merger control. And Mondo, I'm going to ask you to come in here. You sort of flagged this as well, and you said that a lot of the firms that were in distress pre-pandemic. But given the lag period that we always experience in the economy, we're still going to see the fallout from this pandemic in merger control. There are a lot more businesses that are going to come saying they face either distress or failure. And question I have is, we know that it's coming, and I'm sure Dean has already got some of them on his plate. And maybe even Francis says, do we continue assessing these firms in the same way? Do we change our assessment going forward with a view to recovery and reconstruction, and that we then allow vertical or horizontal consolidation because we think that the sector has to recover, rather than looking at the relationship between the firms?
Yes, I think it is going to be very important to get markets to function once more. In this period of the pandemic and perhaps into the near future, I think competition policies should still apply in the same manner. So when we're looking at a failing firm and we're looking at how to assess the failing firm, we should still be looking at important issues that relate to will the assets exit the market? And in our context, of course, we've got the public interest issues as well, which require us to look at the impact on small businesses, the impact on employment, and so on and so on. And so I would say that the provisions to assess failing firms should remain the same, with an understanding of the recovery process or period. The Commission is usually best placed to do an investigation into whether assets will indeed exit the market. Markets are dynamic, they move fast. Yes, they have been impacted by the pandemic. And at this stage, it's anybody's guess how long the recovery will take, and perhaps economists have a better sense of the timing. However, each merger should still be assessed on its own merits, with investigating those elements of whether the firm is indeed failing and whether there are public interest benefits. In the mergers that we reviewed, which were the failing firm mergers, we saw a lot of them in the retail space. We saw some in the airline industry, and we saw some in agriculture. And in all of those sectors, the employment is a big factor, and the assets in question are really good assets that are important in the economy. And therefore, one has to still come back to whether those assets will exit the market, and whether there would be buyers for that, and so do the normal competition assessments, and come out with ultimately a pro-competitive outcome. It may be that for some time during the recovery, those failing firms are still allowed, and the impact of the failing firm will be seen. However, at some point, as I say, it's for purposes of recovery, but in the long term, we should be looking to restore competitive and inclusive markets.
Thanks. Hardin, you want to jump in here and give us your views?
No, thank you, Yasmin. In fact, our Mondo ended, that we should always be mindful of the purpose of our interventions to restore competitive markets. We don't want a situation where we have monopolies post the pandemic, because whatever recovery we think we'll achieve, we will never achieve. In fact, the problems will be worse than we currently face now. So in our view, that standard set for the failing firm, it's a very appropriate standard. I don't think we should tinker with that standard, because we would like firms to demonstrate that they've looked at all options available. And indeed, will these assets exit the market? The difficult cases we face are those of firms in what they call business rescue or facing liquidation. This is a firm now on life support. There's a manager responsible for it. Those have been very difficult, but we have been engaging with the business rescue practitioners, because we have found that they also limit the options for these assets. They don't consider competition at all, and we would like them to do that. So we have been engaging with the business rescue practitioners, because we are always mindful of the impact that the transactions have on competition. If we look, major transactions, notifications declined significantly during the pandemic. We had 302 in 2019-20 and 242 just this financial year. So we had a 30% reduction. We did pick that up even in our filing fees. So, but interestingly, we maintained the number of conditional approvals, which means we were dealing now with all of, so cases that we faced are cases really that had to be notified, addressing all of these problems. And it will still be important to balance, competition against, the pro-competitive gains, the public interest issues that are there. There are some cases, of course. I'm with Mondo. You are there. You've been, Yasmin, looking at some of the cases. I don't want to sort of talk too much about the cases, but there are cases that we had signaled how we interpret these issues at the commission level. The send versus said versus transaction, we had blocked it. We blocked Aveda Thermal is an intermediate measure. You wouldn't have seen it. They do raise some financial issues. Google Fitbit, very interesting transaction. Fitbit argued that it was failing. We had approved it with conditions, but it didn't succeed in the US and Australia. So that measure didn't go through. So there are these issues. And I think we should not, this standard, I think it's a very good standard. It doesn't stifle investments at all. In fact, it gives firms, we would want firms to consider the options genuinely and in good faith. Because I can tell you, we receive cases all of the time. A firm is either in financial, it's ailing. There are some creative words now. We don't even know what to do with that kind of submission. That the firm is ailing, it's not failing. What does that mean? We have a standard. We don't want an in-between standard. I think the tribunal set the standard, Competition Appeal Court set the standard. That's a very appropriate standard for South Africa. And it's a standard that will help with economic recovery and reconstruction. We will have good transactions that will restore competition in markets. We are not going to encourage a situation where we accept monopolies because they are going to magically, assist with some recovery. So this is maybe I speak for myself because of course there is the commission broadly. So that just to be read in that context. Thank you.
No, thank you, Harjin. I'm going to move to you, Francis, for your views. But while you are doing that, can I ask Harjin to look at a question, if you can, on the Q&A? It's related to particularly South African merger control. If you can't, then just let me know. Francis, how would you see this issue of failing, ailing firms or firms in distress? And do you think we should soften our approach to merger control?
One thing, let me agree with Mondo that the analysis criteria has to be the same. The substantial lessening of competition and then the public interests. However, is that we should know and we should be aware of the way the economy is, and we can maybe fast track the analysis of mergers. If at all we have been taking an average of 50 or 40 days, we ensure that we have mechanisms within our organizations to fast track the merger analysis. Why am I saying this? In Nairobi Central Business District now, I have 2 hotels renowned for the people who come to who visit Nairobi. Intercontinental Fairmont, they are closed, 300 bed capacity. It's not functioning. When we go to a small town like Nyeri in the northern circuit of the tourist industry in Kenya, or one of the hotels where the queen slept as a prince and woke up as a queen, it's closed. And then the Outspan Hotel is closed with a bed capacity in that small town, 100 people. So as a competition agency, I have an obligation that when there's someone who would like to take over this kind of investment, I'm aware of the kind not only of competition it can bring in the Nairobi Central Business District, but also in terms of the support it can give to the suppliers to these industries, to employment, and to making the market function better. So the issue of fast-tracking, realigning our workings within the organization, we should be alive to that. The other area I'm seeing also, it's in terms of the retailers. Some of the retailers who have been dealing with especially the imported goods, who have been importing imported goods, unfortunately, I'm talking to South Africans, they have left the market. 2 South African retailers have left the market. Maybe they have now, if at all there's someone who would like to come over and take those spaces, I'm aware that as an agency is that I have to work within the analysis parameters, but also is that I have to fast track. So those are the situations I'm taking into account. Then the other issue is that, and I've always said, is that mergers, they have a cure. You can approve a merger, or approve with conditions, or reject a merger. If it's a situation you're seeing when you weigh both the public interest and the substantial lessening of competition, you can approve with conditions. Number two, even if it causes some kind of a concentration, there are other abuse of dominance provisions you may deal with. These are very personal views I'm engaging. Thank you.
Thank you. That is very interesting. The reason why I asked Hardin to look at that question, everyone can look at it, of course. It relates to our merger topic. And I'll read it out here, which says, it's from Mr. Trevor Mdluli. For the firms that were in distress before the COVID-19 and had their mergers request rejected, was there any further support offered by the government and competition authorities? We are faced by an exponential increasing unemployment rate in South Africa, and therefore closure of businesses will not help at all. Well, I'm not sure. It's a complex question, but Hardin, do you want to take a first step at it?
No, look, I think it's asking, of course, what we have picked up also in research ourselves is that there are many other factors that are contributing to our unemployment crisis or issue in South Africa. So measures do contribute, but it's not, they do not make any significant contribution to that worsening number. I think it's an overall performance of the economy here, and in question, because our economy is not growing. So, but if you look at the transactions that I've just mentioned, the transactions we blocked. One we blocked, tribunal approved, so that was an approval. Aveda Thermal Resources, it's a companies in waste management. They have been, running their businesses profitably, so those businesses would be continuing. But in South Africa, what government has done, it adopted a huge, a stimulus package to address the consequences of the pandemic. So there's huge support for businesses out there. So I think insofar as what this government or has government been doing to reconstruct this economy, I think it's there, it's out there. So I don't think we can say those decisions had a huge impact on employment levels. So yeah. I don't think we are there even in aggregate. So we track these employment numbers, number of jobs caused, it created, by a merger. It's not really big numbers. We're looking at roughly, I think, 60,000 net positive numbers in a year. We have a 12 million, problem where 12 million people are unemployed.
I'm going to leave this question here for a simple reason, is that competition agencies are very mindful of employment effects of mergers. And we seldom have blocked a merger when there have been employment consequences. In fact, we've approved them conditionally unless there were serious other concerns. I want to move on because we are pressed for time and we've got only half an hour left, and I want to still cover two topics with you. So the last one of this round was the issue of agency effectiveness. And Mondo had flagged it in her introduction. And perhaps, Hardin, while you have the floor, you could just speak a little bit about that. And I think the important thing about agency effectiveness is to just learn, from what learn the lessons from this pandemic, and focus on, perhaps, as Professor Fukine said, look at what we need going forward, utilizing what we already have, and perhaps improvements we could make.
No, indeed, I think there's a, I think, you know, Tembi raised this also earlier. He spoke about broad efficiency issues, right? And I think these issues will still be, will be seized with these issues for some time. And I think the pandemic somewhat allowed us to experiment with a couple of things. We were quite responsive as the Competition Commission. I don't think we lost a day, you know, with the pandemic. We had to respond to the issues. We had to immediately shift to remote working, adopt a policy immediately, you know, for our staff on how we would be handling cases, you know, revise, you know, case procedures, although it was also not easy to investigate on the ground, but we were able to obtain the information that we needed. So there is some agility that I saw in the system, that we are able to do more. As you know, I mean, there's been Skype for many years. We have refused ourselves to take official meetings on Skype for many years. So we had people flying all the way to South Africa to meet us. But I think we have now accepted technology, which I think will assist us as we move forward. It will help us to always keep in touch. For authorities, by the way, you know, it has been very difficult to engage, you know, to get our case handlers to talk. Now with these systems, I think it's going to be very seamless. It's going to be very easy for our teams to talk. We are going to see more cooperation between competition authorities. So this is really a great lesson from this, and a great learning that we have from the pandemic. But also, for the first time, we saw the tribunal in South Africa resolving a very complex abuse of dominance case within a very short space of time. We've been notorious for very, very long hearings, you know, cases taking many years. But you can see that this sort of opened a window for us to start looking at possibilities. So I think these are things that we can reflect, you know, upon. Maybe we have to, you know, rethink, you know, the rules, review some of the things, you know, make some refinements. But for us as the commission, this has been a very, you know, I don't want to say it's been a good pandemic because this has been really a terrible pandemic. But this allowed us to experiment with a lot of things. And I really credit to our staff who've been very receptive. You know, they accepted all the, you know, the new interventions we put in place, the new investigation, you know, procedures. You know, we had to invest some resources also, you know, for telephones, for internet. But yeah, I think all in all, you know, for the past 18 months, we are still working remotely. We think we have delivered what needed to be delivered, given the challenges we were facing.
Thank you, Hardin. I noticed you spoke from a commission perspective, which of course you have to, because talking about your agency. And since you've cast some kind of aspersion on the tribunal, let me ask Mondo to give her reflections on the efficiencies that the tribunal embarked on and how she sees it going forward.
Yes, I think Hardin has already mentioned how quickly and swiftly we moved to enable virtual hearings, which had never before the pandemic had been done. We had our first case within the first 2 weeks of going into lockdown. And a lot of work went into that in terms of establishing the protocols for it, but also establishing the rules in support of the regulations that had been issued around excessive pricing, to give specific timelines to force the parties to file within certain specified time periods in order to expedite the process from the beginning of the hearing to the end. I think part of the way that work is done normally is that the time periods generally are long. There are lots of interlocutory proceedings that do take place that can delay proceedings at the tribunal. However, from the pandemic, we learned that there can be some efficiencies. We had some of the cases without hearing any oral evidence. We issued directions that required the parties to file joint statements that indicate what they agree on and what they disagree on, given that the issues were limited around excessive pricing. And therefore that enabled us to really get outcomes quicker than we otherwise do. Indeed, from those learnings, we can look into ways in which we can transport that, or rather import that into other areas of work. One of the things that I mentioned earlier as well is that the cartel cases and abuse cases, by their nature, were held in abeyance during this period. So we are starting to put them back on the roll and to hear them again. And some of the efficiencies we learned from there are going to be helpful in also limiting the amount of time spent on hearings by parties. By way of example, we've got and have had a matter where for one case, we are looking at 60 days of hearing for one matter. And so the issue is, how do we draw out the efficiencies that came out of hearing the matters online into cases that are of a cartel nature or an abuse nature, which require the leading of oral evidence. And there is only so much that we can import some of those efficiencies into those types of cases. However, we are looking always to get our efficiencies improved in that regard. I think the other element to mention here is that the nature of the matters has also become quite complex. Some of the provisions in the amendment have included buyer power provisions, which at some stage, when they do come before the tribunal, we would expect that they would also consume quite a lot of time in hearing. And those are not the kind of matters that one can hear on a paper or virtually. And therefore, we are looking at returning to office subject to the pandemic, which, as we all know, has a mind of its own.
Yeah, but that's very helpful, because what you're saying is that the efficiencies that were gained in the lead time to a hearing can certainly be imported even into a real physical hearing context. I'm going to ask Francis to give us his thoughts about agents' effectiveness, and I just don't want to put too much pressure on you, but you've got 5 minutes. And in that time, Harjin, can you look at a question that's directed specifically to you, after which we will go into our last theme. Francis.
Thank you, Yasmin. And our initial indications is that we achieved more with less resources. We are still doing that kind of an analysis to see how we achieve that. But in terms of efficiency, how we dealt with cases, our performance contracting with the government is that we achieved excellently in terms of the cases we handled and the time taken. We are going to evaluate as an agency in terms of how can we take this forward. But I have to highlight the key issues is that with working remotely, definitely we also took that advantage to become paperless. We established a portal where people have to lodge their mergers, they have to lodge their complaints through the system. And this also reduced the transaction cost for businesses come to our offices to lodge. So also in terms of the printers, photocopiers, operation expenses, we reduce that. The other issue is that in terms of our training budget, we have been able to reorganize it and take it to other focus. We have reduced it by 50%. External traveling, we have reduced it by 90%, but our presence internationally is more. Last week I was in Budapest. Today I'm in Joburg in the morning. In the afternoon I'll be in DC. Then next week I'll be in Dar es Salaam and New York. And that kind of presence, that reduced budget of by 90%, is that I may say it's a blessing in disguise. Moving forward, and I hope my staff members are not listening to me, is that we have to see how we can reduce some of the allowances in terms of the commuter allowances, and see how we can take this to buying of the data bundles to facilitate them to work from home. It's just reshifting from commuter allowance to data bundles. Also, maybe in the long run, we can look at our rental fees. Why should we continue paying for rental fees of about 2 floors or space of about 30,000 square feet, when we can have, even when the COVID is over, when we can reduce that space and reallocate this money to case handling. These are some of the things I'm looking at. The other opportunity I saw, it's the opportunity of working with the government. The pandemic brought all government agencies together. And these are opportunities we can continue working with in terms of removing regulatory obstacles or ensuring that the regulations which are being promulgated are not affecting competition. The other issue is that we have really to look at, Mondo has highlighted it. It's the challenge of procuring evidence. We couldn't do dome rates, and we have to know how we'll be procuring evidence moving forward and processing that kind of evidence, and how we are going to interact with our adjudicatory bodies in terms of presenting the evidence. The other challenge also we have to deal with, it's the cybersecurity. As we have gone through online, is that the attacks will be more, they'll be there, of course, and we have to invest seriously in this kind of attacks. The other challenge I've seen is that the mode of conducting business has changed. It's platforms now, big data, and we have to build capacity within our organizations in terms of appreciating these new emerging areas. That's an area we have to focus on to be credible and effective agents. And lastly is that working remotely, Hardin mentioned about it, the capital in terms of capital outlay, the initial capital outlay. I engage my staff members in developing a master plan moving forward in terms of working remotely. And the sad news is that I've been told that the equipment we have, they may be obsolete or turn into obsolete. That means what kind of investment I have to make. But there are so many other areas, external traveling, we can save on and apply it back to this kind of capital outlay. And the last but not least is that what it has taught me is that agency effectiveness depends a lot with leadership, the flexibility of the leadership, not at the top, but also at departmental level. How do we appreciate new ways of thinking, looking at risks and attending to those risks and ensuring that we go through the storms? Thank you.
Thank you for that, Francis. I'm going to move off this topic, but I do want to say one thing about the virtual environment. And what I have found personally, that it's very difficult to build trust and teams. So, agencies also need to build value around the organization and the culture of the organization, and not to forget that we shouldn't lose that in the process of finding the savings and efficiencies through remote or online work. Moving on, there was a question directed at Hardin around exemptions, and you all can have a look at it. Hardin, if you can take 1 minute to answer that, so that I can then move on to the African Continental Free Trade Agreement topic.
Right, I see. I think it's from Vipal. What I think maybe the answer really is to what I raised earlier about what we published. We published guidelines on competitor collaboration to support localization initiatives, and I've said this, that government as part of economic reconstruction and recovery has identified localization as a driver for that recovery. So we are anticipating a lot of initiatives. In fact, when we released that, there was even a request from various CEOs that they want to get together, engage, and look at opportunities. Are there inputs that they could, reasonably source locally? What other efficiencies could they be thinking about? What other collaboration would they be thinking about? So I think you're going to see a lot of these, cutting across us. And as I've said, I mean, this is also a consideration of, block exemptions for SMEs widely to stimulate these collaboration. So I cannot sort of specifically mention.
And maybe Vipal, you could attend the plenary that will deal with identifying some of those sectors that would be in need of assistance for recovery and reconstruction. So let me move to our last topic, and I'm going to ask Francis to lead us this topic of this. We've had this pandemic, but at the same time, a very exciting initiative has taken place on our continent, which has been the launch of the African Continental Free Trade Agreement. We did speak about it a little bit at the last conference, but a lot has happened since then. And Francis, I would be so pleased if you could bring us into the debates and the discussions, and then Hardine and Mondo can jump in when they feel like it.
I think we don't need to, I will not focus in regard to the benefits of African Continental Free Trade Area based on the trade, because it's obvious is that it's going to increase the critical mass of the Africa in terms of negotiating for better terms with the outside world, and also in terms of ensuring that there's free movement of goods and services across Africa. And taking into account that what I've learned with the pandemic is that most of the Kenyans who are staying in South Africa and they decided to drive across the continent, and if at all, because there were no flights. So what means is that ACFTA, the working of ACFTA, can ease this kind of movement, even when there's a pandemic. Also, in terms of what I've appreciated in terms of of an African Continental Free Trade Area or any free trade area, is that we have a common approach to regulatory interventions. For example, is that I'm of the opinion that we are going to have a critical mass to be able to deal with the platforms. You don't tell me that Kenya can be able to withstand the Google of this world, or the WhatsApp of this world. But when we have a common Africa approach to these platforms, which have become very, very key in terms of facilitating trade within Africa, is that we'll be able to achieve that. Also, in terms of the airline industry, how can we build a critical airline industry within Africa to be able to enhance this kind of trade? But now focusing on on competition regulation, is that I wish to highlight what personally I see that we might be forcing a continental free trade area, have it on paper, but it doesn't work. And a free trade area, my greatest fear is that I hope we are not going to transform the tenets of the free trade area should be well informed. I know we are at negotiations, and I know Hardin is part and parcel of that negotiation. What I'm praying is that we should not transplant national laws and read bad legislations for some countries into the continental arena. Why am I saying that? I see that within the African national competition agencies, you find that there's a lot of threshold and turnover outreach in terms of what farms are supposed to be captured under competition legislation. Some national legislation focus on merger regimes as a way of raising revenue. You know, they don't look at it as a way of encouraging investments. And if at all we transplant that kind of thinking into the African continental free trade area, we might not have the trade area in the first place. Then number two, it's also in terms of the implementation. The biggest challenge in Africa right now is that we don't have bottom-up competition implementation. That at the bottom of the foundation, we don't have national competition agencies which are credible to even support competition regulation within their countries. Now we are at this level where we are seeing that we need to implement that competition at the continental level. Who are going to be the pillars? That is in one part of Africa where we have that challenge. Then we have another part in West Africa where we have top-down, where the regional economic communities, they are more stronger than the national competition agencies. First is that now coming up with a good institutional dispensation and to make the free trade area competition policy work, we have really to sit down, and I'm very happy that the African Competition Forum has been able to agree on some certain parameters. I know we had said that we need some sequencing in terms of the institutional dispensation. I know some countries, they are saying that we really need an institution to move forward, but my greatest fear is as what I've highlighted. Are we running before we know how to work? Also in terms of the persons to enforce, is that even if we form that kind of an continental institution, do we have adequate capacity for people to be able to enforce? Now the other challenge I'm seeing, it's in terms of how do we deal with the reality, which is now a historical anachronism. We have EAC, we have COMESA, we have ACFTA now, we have SADC, and if you look at EAC and COMESA, there's no interface, there's a lot of disjoint, I may say that, and there has been some, what I may call internally some competition, regulatory competition, rather than trying to harmonize their workings. Now, do we first remove this chasm between COMESA and EAC and then move to the continental free trade area? Do we first deal with a tripartite agreement? You know, these are the challenges I'm seeing. And then the most important now, it's in terms of how the trade drivers have changed. You know, right now is that we have data. It's very, very key in moving trade. We have taxation laws also are very key in moving trade and competition laws. Do we first deal with harmonizing these policies at national level and move at continental level so that we can have a working continental free trade area? And from where I stand also, we need to develop not only bilateral agreements on sharing of data, but also come up with a multilateral agreement of sharing of data, because now data has become the key driver of trade. It's not the old enablers of trade. These are new parameters. And I hope as we move forward, as the negotiators move forward, we have these in mind. Thank you.
Thank you, Francis. Those are very interesting developments and of course, highly relevant to reconstruction and recovery. Hajin, if you have any comments on this?
All right, no, thanks, Yasmin. And I think, you know, Francis has laid sort of what you know, the challenges we face currently are on the continent. But I think this is a very, you know, historic thing, to have happened for the continent, because we now have a competition policy alongside, intellectual property and investment as part of, forecast phase 2 issues. They call them phase 2 issues for negotiations. So, which means it is an opportunity for us as competition authorities to shape this competition policy that we'd like to see. And fortunately, for this agreement, it says it is sort of based on the regional economic community. So the building blocks should be those regional economic communities. And our view is, for that to really work well, you need some capacity building, initially, so that we can understand each other when we are talking. And there's definitely need for training on competition regulation across all of these countries. There's a need to ensure that countries adopt laws that are harmonized. I think this discussion will help with some harmonization of rules, because we will definitely, I think we will still have national issues. We will still have regional issues. And what we did not have was a mechanism to address continental issues. And these are issues, around cross-border cartels. These cross-border measures, we were dealing with Google Fitbit. We look at it as South Africa. Ideally, you should be looking at it as a continent, as Francis is saying, all these digital complaints, cases against Google. If we have to look at advertising practices of Google, it would be good to look at this at from a national perspective. So there is this opportunity for the AFCFTA, and I think in negotiations are underway. We are all participating there, with open minds. And I think it's not going to be, an easy process. And I think South Africa is chairing now, and I have the honor, I think, to chair, I think, the first committee meeting, and I think a few others until December. So I think I will probably just leave it a bit here, so that at least I can still remain the impartial chairperson in that.
Congratulations. Mondo, do you have any comments on this? And before I move to bring us to a close.
I would just like to congratulate both Francis and Hardin on the work that they've been doing in this area. And to come back to the point that's been made throughout this session and in the earlier opening session about market power. It transcends boundaries, as we know, through cartels, through mergers, and therefore this initiative, I think, is an important one, and this collaboration would be absolutely critical as we look to shape the future of competition policy going forward, particularly at regional level. The two questions really that I wanted to pose, and perhaps these are still things that are at developmental stage, would be what the impact would be on the existing frameworks such as COMESA, IASA, and also what the timeline is that's expected for this to be up and running. I think that would be good to know.
All right. Unfortunately, we have run out of time, even run out of our extra time that was given to us. And I know I promised you a quick round of last remarks, but I think I'm going to have to be fair to the audience who's been patiently listening to us for more than 1.5 hours, almost 2 hours. To say thank you very much for your participation. Thank you very much for flagging the issues that we need to dig deeper into, and which I think the panels to come will start focusing on, i.e. what are the tools that we need to use going forward for reconstruction and recovery, having learned all the lessons in the pandemic, and which are the sectors that we can identify for those, for utilizing those tools. So I want to thank you, all three of you, for your just immensely wonderful, very inspiring and thought-provoking debate. And I truly want to extend my appreciation on behalf of our hosts, the Tribunal and the Commission, for your participation. And I want to thank the audience for being with us until until this time. Pumi, it's a hand over to you.
Thank you, Yasmin. I think the expression you were looking for is where the rubber hits the road. Yes. And where the rubber hits the road, I think a lot remains to be seen when it comes to our continental integration and creating African unity, and in particular, in those matters where perhaps national interests may be in conflict with regional gains and what may be potential outcomes on that end. So I'm very excited to see what's going to be happening with competition policy on the continental front. So not to eat too much into our lunchtime, one of the other things the pandemic has taught us to do is to be flexible and to be able to adapt to change. And there has been one such change to our program this afternoon. As you've noticed, we've eaten into lunch a little bit, and that's because our lunch will no longer host the lecture by Bill Kovacic. Excuse me. Rather, he will be presenting a little bit later on in the week. So you've got 30 minutes of free time to stretch your legs. And when we come back, we will start off by coming back into this main room. And then what you'll see in the chat function are 2 links that have been added to the chat for academic sessions 1A and academic session 1B. We'll give you more information on what to expect when we resume at 1:30 in the main room. But what you should know now is that there are 2 links associated with each of these academic sessions. The first link is not accompanied by a password, whereas the second one is. Just note that when you're trying to get into the room. And the other thing I just wanted to kind of allow us a little bit of latitude to adapt to is what happens in between lunch and tea. Our moderators will note that whatever we discuss on our platform is live and recorded. So when we need to do some testing beforehand, I note that our attendees have been privy to some of our water cooler conversations, which I think is a great humanizing factor of what it means to be virtual in these times. But I'll just remind our moderators to keep that in mind, that while we are on break, and if you need to discuss any testing features, that we are in fact visible to the public and our attendees and are being streamed live on YouTube. I think that covers everything. Enjoy your lunch, replenish yourself, because we have an action-packed session planned for the remainder of the day. Thank you.